The Senate Judiciary Committee will come to order. We'll see if we have a quorum. Please call the roll.
Mr. Chair, you have a quorum.
Okay, thank you. The first bill, we'll get down in order. House Bill 731, Delegate Ward. It's juvenile law enforcement records. It's identical to Senator Norman's Senate Bill 149 that was reported 15-0 and passed the Senate by 40-0. Is
Mr.
Delegate
Chair,
Ward here? Yeah.
Mr. Chair, I do have a technical amendment to this bill that I know Senator Norman's in agreement with. It's on line 58, insert after law or rule of Supreme Court of Virginia.
Okay. Is there a motion to adopt the amendment? It's been moved and seconded that the amendment be adopted. Say aye. All in favor say aye if you like it. Say aye or no. Say aye. All opposed, no. The amendment is adopted. Anybody want to say anything about the bill? Is there a motion that we report the bill as amended?
Move to report.
Been moved and seconded that this House Bill 731 of Delegate Ward be reported as amended. All in favor of the motion, vote aye. All opposed, no.
Ayes 8, no 0.
8-0, the motion carries. The bill is reported. All right, House bills with Senate companions, contested or not, or conforming amendments to be considered. All right, House Bill 228, Delegate Corner. It eliminates the authority of the juvenile justice to establish juvenile boot camps and the ability of a court to order a juvenile adjudicated delinquent to attend such boot camp. It's identical to Senator Marsden's Senate Bill 546, reported 12-2, passed by the Senate 35-5.
Move to report.
Is there, do we need to conform it?
No, Mr. Chair.
Okay.
This needs to go to finance, so the correct motion be report and refer to finance.
Refer to finance.
Okay. There's no presenter, but if anybody like to hear the presenter? All right. There's a motion that we report the bill and re-refer to finance. All in favor of House Bill 228 to be reported and re-referred to finance, vote aye. All opposed, no.
Ayes 8, noes 1.
8-1. The bill is reported and re-referred to finance. Senate Bill, House Bill 623, Delegate Hudson, guardianship and conservatorship. I've been asked, should this go by for the day? I have written down here, by for the day. Is that right?
Yes, Mr.
With-
Chairman,
with
the two guardianship bills need to go by for the day.
Okay, without objection, House Bill 623 will go by for the day. House Bill 634, Delegate Rome, Department of the Aging, I had to note that this should go by for the day as well.
Yes, please, Mr.
All
Chairman.
right, without objection, House Bill 634, Delegate Rome's bill will go by for the day. House Bill 1212,
That one too, Mr. Chairman. Thank
and
you.
we're going to guardianship bill. And with that, without objection, House Bill 1212 of Delegate Glass will go by for the day without objection. So ordered. Next is House Bills, Delegate Simons, House Bill 258, having to do with human trafficking. I believe there's some amendment.
Mr. Chair, I do have a substitute to put this bill in the proper form, and I believe Delegate Simons will repeat what I'm saying, but basically the substitute got left in the House General Laws. They voted on this language, but for some reason the substitute didn't attach. And basically the substitute from the introduced language differs in one tiny respect, and that is that the Department of Criminal Justice Services would have to approve any online course within 60 days of submission. And
Is there a motion to adopt that substitute? Moved and seconded that the substitute, the amendment, is it substitute or amendment? The substitute be adopted. All in favor of the motion, vote, say aye. Aye. All opposed, no. Motion carries. Okay, it was supposed to be done in the House, but it was not done. Is that right? So this is a fix, sort of. Anything you'd like to say, Delegate Simons?
Thank you. We were negotiating with the hospitality industry, and they wanted us to have that 60 days that DCGS would need to either approve or disapprove of the human trafficking recognition training. This is just part of making sure bystanders are empowered to report any suspected cases of human trafficking.
Is this recommended by the Criminal
And
Justice
Mr.
Services
Chair,
Board? Yeah.
That substitute somehow got approved by the committee, but it wasn't correctly.
Wasn't
Transmitted,
properly
and
done.
I
Technical error. Okay.
yeah.
Okay.
Adopt the substitute.
We've already adopted.
We already adopted the substitute. Anything else? It has to, was this a recommendation of the
Finance.
Department of Criminal Justice Services? Was that a recommendation or what?
I believe that the Attorney General's office
Okay.
has endorsed the bill, and I have been in contact with DCJS, and they helped me with it.
And we refer to finance.
Okay, it's been moved and
That's what?
it applies to hotels. No matter how large or how small.
Did
Yeah,
the
Senator
amendment change
Morrissey.
So what do you?
Yeah, Senator Morrissey.
I'll defer to Senator Dees, and then I have a
Okay,
question.
Senator Dees.
I was just going to ask Steve to elaborate that. I mean, what,
Mr. Chairman, Senator Dietz, I just wanted to point out, for a policy consideration, the breadth of the bill. It covers every hotel, no matter the size.
Mr. Chairman?
Yeah, Senator
Would that
McDougal.
include Airbnbs and?
Are they hotels?
Mr. Chairman, Senator Obenshain, I don't think it would include Airbnb, but the definition of hotel is contained within the section. It means any place offered to the public for compensation, transitory lodging or sleeping accommodations, overnight or otherwise, including facilities known by varying nomenclatures or designations as hotels, motels, travel lodges, travel tourist homes, or hostels. I don't think it would be Airbnbs, but I just wanted to point out the breadth of it.
Mr. Chairman,
Yeah, Senator Obenshain.
is it, oh, I'm sorry.
Thank you.
Senator Morrissey.
First of all, my first question was answered by staff regarding what is a hotel. It's not just a hotel, it's a motel, and not just, it includes everything from Marriott to the motels on Laburnum Avenue that rent out the rooms by the hour. That's how I understand the bill. My question is this: what is the nature of the training course on recognizing and reporting instances of suspected human trafficking? How extensive is this, and will every employee of the Marriott and the Omni take the same course that the small 10-room motel on Chamberlain Avenue has to take?
That's a great question. May I answer it,
Yeah, please
Mr.
do.
Chair? So currently, the large hotel brands do this kind of training. And we worked with the hospitality industry to make sure that the existing training can be counted as part of the human trafficking recognition training. And when I met with a hotel manager in Newport News of the Holiday Inn, she said that this would actually be helpful to get standards all across the industry. They had a situation where a lower tier hotel wanted to become a Holiday Inn, and they didn't do any human trafficking recognition training with their employees. So this will kind of lift up the standards for all motels and
Okay.
motels. And right now, the training is being developed by DCJS through a learning management system that they have, and it can be done online. And it is not an onerous training.
Yeah, okay, Senator Morrissey.
All right. Let me ask this. You're familiar with the phrase, the sex worker industry, people that are involved in that industry, correct? Does this training include prostitution, or is it just human trafficking? Because in the last 2 years, we see more and more and more bills that have the phrase human trafficking, which gets everybody's radar going. Is there a reason you have human trafficking in here but not prostitution?
So when, Mr. Chair, when I consulted with DCGS about this bill, they said that right now the code is geared toward sex trafficking, as Senator Morrissey correctly says. Human trafficking tends to be more of an overarching term that the federal government is using a lot more, because we do have a lot of labor trafficking happening now in Virginia, and so it's just a more encompassing term, so that's the reason we used human trafficking in this case. But, you know, I've been contacted by our law enforcement in Newport News, and this, in terms of sex trafficking, is a really big problem in many of our cities, so it would cover that.
Senator Obenshain?
Do you know how long the online training will take to complete?
Not sure if we have anyone from DCJS here who could answer that question, but my understanding is it's a brief training, an hour. I've asked that question, like an hour-long training.
Okay. Anybody? Steve, you have something to say? Steve Mitchell?
I do. Absolutely laudable purpose. Great idea. I have to point out, I have to correct myself. I think the definition of hotel would include Airbnb. That's point one. Point two, line 315 requires that each hotel employee shall complete the training. I don't know whether that's the patron's intent, because that definition, I think, would include groundskeepers, people who may not be in the logical chain of reporters.
All right. You have somebody you want to speak in favor of the bill?
Oh, I've got someone here who can
Yeah.
answer some of those questions.
Come on, yeah, speak your name?
Yes, Mr. Chair. Olivia McCormick. I'm with the Virginia Department of Health. I can confirm that a hotel does not include what we would think of as an Airbnb.
Mr. Chairman?
Yeah, Steve?
I would only say that I'm reading the definition of hotel being any place that offers transitory lodging or sleeping accommodations overnight or otherwise.
Yes, sir. There's other language elsewhere in the code, unfortunately I can't remember it right now, that actually establishes that these are mutually exclusive categories when it comes to a locality's ability to establish ordinances regarding Airbnb. And it establishes that they are mutually exclusive from entities regulated as a hotel under Title 35.1.
Okay, anybody else? You want to pass it by temporarily to get this?
Mr.
issue
Chairman, the only
resolved?
suggestion I would make is that if that is the case, then a cross-reference
Right.
within the bill would be helpful to the statutory provision that clarifies that Airbnbs are not hotels for purposes of this section.
Shall we pass it by temporarily to get this fixed? Okay?
Well,
Mr.
okay.
Chair, I would consider that a friendly amendment to
Mr.
the
Chair,
bill.
if I mean, who do you want to include? Are you trying, hotels, motels, bed and breakfasts?
So I was working with the definition of hotels that our friend referenced for this bill, but in negotiations with the hospitality industry over this bill, I did tell them that I would work on a new bill for next session covering Airbnbs, because the hospitality industry does want Airbnbs to be covered. But our understanding is that they are not covered in this bill.
Well, shall we temporarily pass it by so you can look and have Kristen or Charles look at it?
Senator Morrissey.
Yeah, Senator Morrissey, go ahead. Senator Morrissey?
Mr. Chair, so for state campgrounds, campground is defined differently. There is a definition for campground in the hotel title. So campgrounds would not be included in the definition of hotels. The Airbnbs are called short-term rental properties, I believe, in Title 58.1. So they also would not be included in hotels as
Do you want to
contemplated in the
have
code.
an amendment to make it clear that not including X, Y, and Z?
So, yeah, Mr. Chair, if we wanted to, we can add a new subsection C and essentially say, As used in this section, the term hotel shall not include short-term rental properties as defined in 58.1, 3510.4.
Okay, is that an amendment? Senator Dees makes that, moves that
I'll
amendment?
make that amendment if that's enough. I mean, does that include the campgrounds as well?
So campgrounds have a separate definition within the title of 35.1. So considering hotel and campground have two definitions, and they don't seem to be inclusive of each other, because campground means any area, place, parcel, or tract of land intended for occupancy or occupancy wholly in part for camping units. I can add in, though, if you wanted to, for purposes of this section, the term hotel does not include campgrounds and short-term rental properties, if that is the desire of the committee to exclude both of them.
Is that acceptable? Senator Dees?
If you think campgrounds are excluded without that language, that's fine. We don't need to do that. But it just Airbnbs, I think, the exclusion would be good.
Senator Morrissey?
To the patron, I don't want you to take this question as me not thinking that your bill is noble and laudable, but here's what I'm trying to wrap my head around right now. We all know what you're trying to get at. We're talking about the generally man, sometimes it's a team, that bring women up to hotels, motels. They advertise sometimes digitally, and there's a parade, they pay in cash, and there's a parade of men in cars coming in that visit the women for a short period of time and then leave. We get it. And that's what you're trying, but what I'm trying to wrap my head around is our putting in the code that we're now requiring training of everybody there to do something that we already, what will they get trained on? If you see a bunch of cars coming in, paying cash and going out, you know what's going on. What is the training that's necessary for this? That's what I'm.
Yeah, go ahead.
Mr. Chair.
Go ahead.
This is a well-established practice with major hotel brands, and I think the training that they're doing is how to recognize and how to report properly suspected cases of human trafficking. Human trafficking recognition training was required in a bill that I passed last session for all casino employees. And it's just a way for bystanders to be empowered that if they see something, they know how to say something and report suspected cases.
Okay, anybody else have any questions? I do, sir. So we have a motion.
Couple down, whoa.
Yes, Senator Norman.
Thank you very much. I understand what the delegate's trying to get to, and I apologize, I'm late to the party, so if I miss something, it's redundant. First of all, is there any sanction if the hotelers do not comply with the provisions of your bill?
My bill does not have any sanctions. It is establishing best practice and requiring the hotels to complete the training. They do need to keep on file proof that employees have conducted the training. DCJS has just invested in a learning management system, so they finally have capacity to actually do online training with all the hotel employees.
I'm coming to that in just a minute. If I could.
Yes, Senator Norman.
Thank you, Mr. Chairman. If I could ask counsel, is there a sanction for this, sir?
Mr. Chairman, elsewhere in the section, and the patron's right, not in her bill, but elsewhere in the section, there is a penalty for failing to abide by any provision of the title. And that would be both a Class 3 misdemeanor for each day of violation and a civil penalty not to exceed $10,000 for each violation.
Okay.
And each day of violation shall constitute a separate offense.
Okay. Any other questions?
Yes, sir.
Yes, Senator Norman.
Thank you, Mr. Chairman. Does DCJS contemplate that there will be a cost associated with taking this online training, because there are some things under ABC where you take a tip training and stuff as a cost?
Well, I hope I'm not speaking out of school, but I know that they are looking for another employee to help them with this, and there is a budget amendment attached to this. I have worked closely with them, and they're hoping to be able to expand what they do in this area.
Okay.
That's
Senator
why it has to
Deeds.
be reported, or if it's reported, it's reported and re-referred to
Yes, sir.
finance.
And my last
Senator Norman.
question is, and is maybe a little argumentative. And knowing quite a bit about the tourism industry, it is very challenging right now to hire individuals to work in the hospitality industry, but particularly in hotels right now, getting your frontline people, and that's for a variety of reasons. And because it's so challenging, have you contemplated the difficulty in hiring people in this atmosphere when they're told that they have to go through this training within 60 days?
So, Mr. Chair, I have
Simon.
worked with the hospitality industry on the bill and gotten a positive response because they're already doing this training. The major brands like Marriott and Hilton, they're already doing this training. And I really think it shows a lot of caring for employees, acknowledging that we're all in this together, making sure that people are empowered, that they know how to report cases of human trafficking. So I would say this is best practice in the industry, and I think employees like knowing what to do when they suspect cases.
Okay, any further discussion? Is there a motion to report is a substitute, the motion to report the bill as amended and re-refer to finance? Is there a motion? Been moved and seconded the bill be reported and re-referred to finance. All in favor of the motion, vote aye.
Ayes 11, noes 2.
11 to 2, the bill is reported and re-referred to finance.
All
Yeah,
right.
thank you, Delegate Simons.
Thank you, committee.
Appreciate it. All right, Delegate Sullivan, 397 is identical to? Stanley. Is it, okay. 755. Yes, Senator
Mr. Chairman,
Louise
I'd like to
Lucas.
move that, that Delegate Sullivan's bill, House Bill 397, be conformed to Senate Bill 755.
And this has to do with compensation for wrongful incarceration,
That is correct.
right?
Yes,
Anything-
Mr. Chairman.
Anything you'd like to say? Anything you would like to say?
This is an important area for us to be legislating in, and I look forward to working this out.
Okay, good. All right, all in favor of the motion to report, we don't have to go to finance. Yeah, report and re-refer to finance, House Bill 397 of Delegate Sullivan's, all in favor? Do we have to confirm it?
I made the motion
Oh,
for
okay, I'm
conformity.
sorry.
Mr.
The motion
Chairman.
has been made and seconded to
Mr.
conform
Chairman.
House Bill 397 to Senate Bill 758.
755.
755, I'm sorry. All right, the motion to conform, say aye.
Aye.
All opposed, no. The motion is now ready to go. Senator Obenchain.
Yeah, am I correct that this requires the payments to be made in lump sum?
Current statute has a lump sum and then an annuity. This bill makes the lump sum a larger portion, but does not do away with the annuity. It still has I believe we shortened it to a 10-year annuity.
Is that your bill or Senator Lucas's bill?
My bill in its current form retains a partial annuity.
You mean as conformed?
As conformed, it does not. It makes it all a lump sum. Senator Lucas's bill makes it
I
all a lump
understand
sum.
now. Thank you.
Yes.
Thank you, Mr. Chairman.
Okay, everybody understand? The motion to report and re-refer to finance. All in favor of the motion to report and re-refer to finance, House Bill 397, vote aye. All opposed, no.
Ayes 13, no 0.
13 to 0.
Thank you,
Okay.
Mr. Chairman, members of
Thank
the
you,
committee.
Delegate Sullivan. All right, Delegate Delaney, House Bill 404, admission into evidence of certain forensic medical exams. Delegate Delaney here? It was Huh? I'm sorry.
You got it.
Yeah, okay, we'll pass by temporarily. House Bill 422, delegate hearing, writ of actual innocence.
Good afternoon, Mr. Chair and members
Good afternoon.
of the committee. This is 422, the writ of actual innocence, based on previously unknown or unavailable non-biological evidence. This bill removes the 21-day clause that's currently in the law concerning a writ. The law authorizes petitions of innocence based on previously known or unavailable evidence. However, to be deemed previously or unknown or unavailable, the petitioner must show the evidence could not, by the exercise of diligence, have been discovered or obtained before the expiration of the 21 days following the entry of the final order of conviction or adjudication of delinquency by the circuit court. This bill removes the language concerning the 21-day limitation. So basically, it will provide that is, it could not have been discovered before the entry of the final order. And basically, that's the bill.
Anybody have any questions of the patron? Anybody want to speak? Yes, Senator Morsi.
Mr. Chair, this is the first bill in the movement towards eliminating the antiquated 21-day rule in Virginia. It's a step in the right direction, and I hope that someday, very soon, that antiquated rule will be eliminated. I support the bill.
Okay. Anybody have any other questions or comments? Anybody want to speak? It passed unanimously in the House. Okay. Is a motion been moved and seconded to report House Bill 422? All in favor of the motion, vote aye. All opposed, no.
Ayes 13, no zero.
13-0, the bill is reported.
All right, thank you, Mr. Chair.
Thank you.
Thank you.
Thank you. Now, House Bill 434, Delegate Sewell, and she has, you like it the way it is, you don't want to amend it, right?
Yes. Thank you, Mr. Chair. Mr. Chair, members of the committee, House Bill 434 expands the definition of intimate parts and protections for victims of criminal sexual assault. This bill was inspired by my constituent. At the young age of 12 years old, she had to fight off the sexual assault of a 37-year-old man. Despite proper reporting to law enforcement, my constituent perpetrator walks free because she referred to her chest and not her breast on the witness stand. I wish I could tell you that this is the only case of this nature. Similar rulings have been made in other judicial circuits in Virginia, all due to the simple word choice of a child. We have the opportunity to prevent this from happening to others. Mr. Chair, if it is the will of the committee, I would love to have the grandfather of the victim I referenced provide further testimony.
Okay. Yeah, very briefly.
Today with us, we have Mr. Harry Wiggins.
Okay, Mr. Williams, welcome.
Thank you, Mr. Chair.
Yeah.
Members of the committee, my name is Harry Wiggins. The situation was I had a 12-year-old granddaughter who was sexually assaulted by a 37-year-old man. He initially pleaded to aggravated assault, sexual assault, and would go on the sexual predators list. He, at the time of sentencing, he withdrew his plea and wanted a jury trial. Went to trial 4 or 5 months later, and my granddaughter had to testify, and the jury found him guilty, recommended a 5-year sentence in a state prison. He then refused to have the psychiatric evaluation that is required prior to sentencing. 5 months later, he's back in court. He agreed to the evaluation. At the next hearing, he appealed the sentencing prior to sentencing. The judge overturned the jury verdict, and he walked out of the courtroom. In doing some research on this situation, I found the same thing happening in 5 other judicial circuits, 7 cases in 5 other judicial circuits. I'd ask the committee to move this bill to the floor and try to prevent this from happening again, because right now we have a pedophile roaming around Virginia. Thank you.
Okay, thank you.
Mr. Chair.
Now, Senator Morrissey.
Mr. Williams, first of all, I'm sorry for your experience, and I was talking with Senator Stanley for a moment. You were describing the assault by this individual on your 12-year-old granddaughter?
Granddaughter.
Again, I apologize. Did you say it was in the midst of an attempted rape, or what? Could you just repeat that, because I've got a couple of questions.
Yeah, she was in her bed doing homework. After, I think it was around 8 or 8:30 at night. And this man was known to the family. He came into her bedroom and lifted up her, she had a sweatshirt on, lifted up her sweatshirt, put his head on her chest, attempted to pull her sweatpants down. She started screaming and kicking, etc. And he got up and
Mr. Wiggins, you don't,
and ran out of the house.
This is
okay.
tough for you to have to go through.
That's okay. That's okay. Did somebody else want?
One further
Just a
question.
minute, just a minute.
Was the defendant charged with attempted aggravated sexual battery or attempted rape?
Aggravated sexual assault.
He was charged with attempted aggravated sexual assault? Or was he charged with aggravated sexual assault?
Aggravated sexual assault.
All right, thank you.
All right. Yeah, just a minute. Senator Sorrell.
Hey, Mr. Chairman, I'm sorry. I was talking with Mr. Benjamin about this, and I think there's a way to accomplish the exact same result that Delegate Sewell's seeking without causing unintended consequences. And I think we ought to just talk about that quickly before we.
Well, is, somebody else wants to speak? No? Okay. Yeah, I think there may be an issue concerning.
Wants to speak.
Yeah, would you like to say something? Yeah, okay.
wants to speak.
All right, go ahead.
Good afternoon. Thank you, Mr. Chair. My name is Erin Earp. I'm Senior Legislative Policy Counsel at the Rape, Abuse, and Incest National Network, and I'm here today to voice RAIN's support for the bill.
Okay, thanks. Okay, Senator Sorrell, do you say you think there's an issue that needs to be fixed?
Well, Mr. Benjamin had a thought. I think we maybe want to talk about it really quick.
Mr. Chairman, the patron was conscientious enough to contact us prior to today's hearing so we could discuss the goal of the legislation and any potential issues, and I think recognized that there was a potential issue in including the general area of chest as a defined intimate part. And I say that because certainly here the conduct that was involved dealt with intimate parts, but the witness, as I understood it, used the word chest. And the concern that several of us had was that the chest area is not historically or commonly thought of as a private part. And we were concerned about adding to the definition of intimate parts an area of the body that isn't typically considered an intimate part. And that drew us to a concern that this committee always has about line drawing. If we include chest as an intimate part this session, where will we stop? Why not make every area of the body an intimate part if performed with this kind of intent? But in order to avoid that problem and those concerns and still reach the conduct that we understood the bill targeted, we suggested that the definition of sexual abuse be expanded so that it would include for any witness, any complaining witness under the age of 13, if someone intentionally touches the skin of the complaining witness's chest, that would be included as sexual abuse.
Well, touching the skin, that's pretty broad, isn't it?
It's under 13, and arguably, nobody should be touching the skin of any area of someone under 13 with a lascivious intent.
I'm not sure that, Mr. Benjamin, I'm not sure that I want them touching the outer clothing of the chest of a
And Mr.
12-year-old
Chairman,
either.
we recognize that if it's with that intent, but intent is always inferred and leaves people vulnerable to arrest and accusation. We were concerned about school teachers having to, forgive the word, herd school children through the playground who might make innocent touchings of the chest area and then be accused of a sexual offense even though they didn't have the intent. We saw the potential for abuse and tried to narrow this bill as much as we could to ensure that we dealt with the target and the concern that the patron had. Bottom line, chest is not a private part.
As currently defined, yes. Mr. Chairman,
Yeah,
I just
yeah.
also would like to
Delegate, go ahead.
offer up the fact that buttocks is referred to as an intimate part, and as we all know in sports, you pat each other on the behind, on the buttocks, and that has become common practice. So I think that we are also only talking about a definition within the legal definition of criminal sexual assault when we are referring to intimate parts. So I think that we just need to recognize the scope of the definition.
Yeah, Senator Morsi.
Delegate, notwithstanding that you talked about football players touching each other on the behind, you still have Section 6 that it has to be done with the intent to sexually molest. The concern with staff here, and so therefore, chest thumping or slapping somebody on the buttocks is not done with the intent to sexually molest, but the concern among staff and mine is we are for the first time putting in the legislation that an intimate part is something that is decidedly and measurably not intimate. That's the problem that I have with this legislation.
Thank you. Mr. Chairman, I would simply say to the senator, I appreciate your thoughts, and I would simply say that we are talking about sexual gratification or the desire to molest or arouse. So no matter what the definition for intimate parts stands to be, we have to recognize the scope of sexual abuse.
I have a motion, Mr. Chair.
Yeah, Senator Morsi.
I think that the substitute drafted by staff is the best vehicle to capture the intent of the patron's legislation and at the same time not expand this legislation beyond what we normally consider to be intimate parts. So for that reason, I'm going to move, if it hasn't already been moved, that amendment by staff.
All right, it's been moved that the amendment you have in front of you be adopted. Any discussion on this?
Yep, Mr. Chairman,
Senator
can we go by,
Serval.
can we go by temporarily for a minute so we can talk to the patron about it?
Yeah, let's pass this by temporarily.
Okay, thanks.
All right, okay, we'll come back to this. Okay, the next bill, while we work on that one, where are we? The next bill is House Bill 451, patron is Bennett Parker, stalking venue penalty. Okay?
Thank you, Mr. Chair. I do have an amendment in the nature of a substitute.
I'm sorry?
Oh, I have an amendment in the nature of a substitute.
Okay. Is motion to adopt the amendment in the nature of a substitute. Is there motion? Senator McClellan moves and Senator Morsi seconds the motion to adopt the substitute. All in favor say aye. Aye. All opposed, no. The motion carries. Okay?
Thank you, Mr. Chair. This bill allows for the conviction of a person who is engaged in stalking conduct that places an individual within the Commonwealth in reasonable fear of death, criminal sexual assault, or bodily injury to him or herself or a family or household member, regardless of the location of the perpetrator of that conduct. Currently, the prosecution of stalking is limited to circumstances in which a person engages in that conduct at least once in the jurisdiction where the person is tried. The substitute simply clarifies that the conduct will be prosecuted in the jurisdiction where the victim resides or resided at the time of receiving the communication. This bill would not change the definition of stalking. It merely changes the venue clause, consistent with how the code treats other crimes, and would ensure justice for victims.
This loophole in the code was brought to me by a constituent and our Commonwealth's attorney. My constituent would be here today to tell you her story herself. However, what has happened to her has deeply impacted her life, and she is not safe sharing this personally or publicly. I have shared that information with you or your offices. As she has described, fear and the trauma that results from harassment and stalking is debilitating. Our Commonwealth's Attorney Office wanted to intervene, but they did not believe this individual would be found guilty under the current statute and in the absence of case law. This bill has the support of advocacy groups dedicated to preventing sexual and domestic violence, the Virginia Commonwealth Attorneys Association, the Virginia Association of Chiefs of Police, the Virginia Sheriff's Association, the Virginia Police Benevolent Association, our Alexandria City Council, and members and mayor. I believe a few representatives from these groups are here in person or virtually to speak in favor of the bill, including Michael Newman, the Commonwealth's Attorney for Danville. Thank you, Mr. Chairman.
Okay. Any questions of the patron? Yes, Senator Morrissey.
First of all, I want to thank the patron for, we spoke about this bill and you explained the genesis of it. Let me just make sure I understand this correctly and then that the panel does. This is the stalking statute that now allows an individual to be convicted of stalking if he or she isn't even in the jurisdiction where the victim was stalked. Is that right?
I believe so, yes.
All right. Now, that you would agree is a sea change in what stalking has been since the stalking statute was enacted. You have to actually be in the jurisdiction to stalk. You would agree, right?
Mr. Chairman, to the senator, I would say that the bill does not change the definition of stalking. It just changes that venue clause. Previously, conduct outside of the Commonwealth was admissible into these cases.
Follow-up question.
Yes, Senator Morrissey.
What I understand your bill is trying to accomplish is that a person in Wise County who is telephoning or communicating with somebody in Henrico County, before, in order to be convicted of stalking, the person in Wise County had to commit at least one incident in Henrico County, but now they can be convicted of stalking if they never leave Wise County, but they make some type of threat over the phone or communicate some type of desire to intimidate that person. Is that right?
If the behavior rose to the level of involving the victim being placed in reasonable fear of death, criminal, sexual assault, or bodily harm to themselves or a family member, then, and that would allow that prosecution, yes.
Final question, Mr. Chair.
Senator Morrissey.
Don't we already have legislation that prohibits somebody in Wise County who is communicating to that victim in Henrico County over the phone, through the internet, et cetera, by making threatening calls or the like? Wouldn't that be covered under existing legislation?
Mr. Chairman, to the senator, I would say that it would not be because the section the senator refers to, 18.260 on threats, requires an explicit written threat to do bodily harm. And in many stalking cases, the behavior will be unsettling, but it will not involve direct explicit threats. For example, messages like, no one else can have you if I can't, or you're going to have my baby. Things like that are not explicit threats. And the bill, again, requires that the conduct places the victim in reasonable fear of death, criminal, sexual assault, or bodily injury.
Mr. Chairman, that begs a final question. Isn't it true that it doesn't have to be written, but rather an individual can communicate with somebody over the phone, in the internet, and in the virtual world, and can communicate that threat, written or otherwise, and still be covered under existing law?
I believe the section on threats does require that it be written and does not include oral.
Okay, all right, thank you.
That's enough. Any other question of the patron? I have a question of counsel. Is there any due process issue here?
Mr. Chairman, there is not.
Steve, okay, all right. All right.
Mr. Chair.
Anybody else would like to speak for the bill?
Mr. Chair.
Yeah, who's
Peterson.
Senator Peterson, okay.
First of all, I like this bill, okay? I like it because I've had people calling and harassing me from around the state on various issues, and I would love to shut them up. But notwithstanding that, I realize that's a First Amendment issue. I can't get past that. My question is somewhat similar to what Senator Morrissey said, and I practice in the civil sphere where we have international shoe and you know, the idea of substantive due process. if somebody lives out of state, I assume we can't prosecute them because we just wouldn't have jurisdiction over them. Am I correct? Steve, where's Senator Benjamin?
Ordinarily, I think that would be correct.
Okay, so now we're talking about another resident of Virginia, and the question would be whether, say, Fairfax County would have jurisdiction over that person if they were, say, in Virginia Beach or Richmond and making a phone call or sending an email or making some type of threatening message or series of messages.
Okay.
I guess that's what we're doing
Is
here.
that a question? Is that a question?
Yeah, so I guess the question is, is this going to be a violation of substantive due process under the U.S. Constitution or anything like that?
Mr. Chairman, Senator Peterson, I'm pretty creative, but I don't see it.
Okay, all right. I like the bill then. That's my point. Okay.
Is anybody else who would like to speak next? Yeah, in favor of the bill?
Good afternoon, Michael Newman, Commonwealth Attorney in Danville. I'm here on behalf of VACA. We support this bill and attempt to address one of your questions, Senator Morrissey, if I might. I believe some of the code sections you're making reference to is not only 18.260 as relates to written threat, but also computer harassment. But that's why we have a separate stalking charge altogether, because there's different elements in all three. Right. And you would have to still meet the stalking requirement. So you could be, someone could do a computer harassment that's different than the elements in the stalking, same as relates to a written threat. Plus, a stalking would require more than one, whereas a written threat will only one involvement, or a computer harassment, just one conduct. So I would respectfully submit, I believe there is a distinction between the three. Only thing this does, look, we have cyber threats all the time. That's why the specific code section dealing with threats have expanded to where the individual received the threat, even if the defendant is not in that jurisdiction. This merely is expanding a stalking to meet that same sort of allowance for a victim to receive.
Okay. All right, thanks. Senator Deeds has a question.
Did you say Danville? Are you walking in the shoes of Bill Fuller?
No one can walk in the shoes of Bill Fuller.
Yeah.
I did come after him, but no one can walk in the shoes of Mr. Fuller.
Who'd you say?
Bill Fuller.
Bill Fuller.
He's Commonwealth Attorney down there.
For 40-some years, yes.
Yeah,
No one can walk in those shoes, Senator.
I know Bill Fuller. Okay. Anybody else have any questions of this witness? We got to move along.
I got a question of staff. Am I the only one in this room who realizes that you can be charged with making a threat, including the activity that the patron objects to, over the phone from a jurisdiction outside of the venue where the person is prosecuted? You have mentioned in writing, you've mentioned cyber threats. The patron mentioned it had to be written twice. Do we or do we not have existing legislation that makes it unlawful for somebody to make a threat over the phone from a contiguous jurisdiction in the Commonwealth?
I think under federal law, you can do that. As long as the wires, the interstate wires. Okay. Anybody else want to speak? Infia, come on up.
What was the answer?
I have no problem with the due process issue. Go ahead.
Thank you again, Mr. Chair. RAIN is in support of this bill.
You what?
Here to say RAIN is in support of the bill.
Who is?
The Rape, Abuse, and Incest National Network.
What do you call it? I can't hear you.
RAIN, the Rape, Abuse, and Incest National Network.
Okay, all right, okay, thank you. All right, next.
Mr. Chair, members of the committee, Jonathan Iglesias with It's Another Mouthful, Virginia Sexual and Domestic Violence Action Alliance. We support this bill.
Okay, next.
Mr. Chairman, members of the committee, Sean McGowan, Virginia Police Benevolent Association, we support the bill.
Okay, is there a motion? Anybody?
I move the bill be reported
Referred to finance.
and referred to
All right,
finance.
the substitute, the motion is the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, noes 1.
Okay, thank you.
Thank you, Mr. Chairman.
All right, now Senate Bill 502, Delegate Mullen. Credit for time spent in confinement.
Good afternoon, Mr. Chair, and I apologize, when I was speaking with you earlier, I was talking about a different bill. This is Senate Bill 502, which comes on behalf of the Virginia Criminal Justice Services VCJC, pardon me.
Okay.
This involves those instances in which someone who has been experiencing a null pros, a dismissal that is not for cause or something like on a charge, and then is subsequently indicted or brought on that exact same charge from that exact same incident, would still be able to receive credit for the time that they spent in confinement. Currently, there is a loophole that allows for what we would call dead time. You know, somebody who is in there in general district court for 30, 60 days, and then all of a sudden it goes away. And so this bill would fix that problem and allow for it.
Okay. All right, any questions of the patron? I see it got through the House pretty well. Is anyone speak in favor of it? No, okay.
Yes, again, Michael Newman, City of Danville, for VACA. We are definitely in favor of this bill. Thank you.
Okay. It's been moved and seconded to report House Bill 502. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
Okay, 15-0. Motion carries. Congratulations. All right, you have another one?
No, Mr. Chair, thank you very much.
Okay. House Bill 557, Delegate O'Quinn. This is a conveyance bill. Disposition of property.
Yes, sir, Mr. Chairman. So House Bill 557 would authorize the governor to permanently convey a portion of property previously used by the Department of Behavioral Health on the campus of...
Mr. Chair, can I ask a question?
Yeah,
Wasn't there a bill last year to convey a piece of this facility to the county or somebody else?
Yes, sir, Mr. Chairman, Senator Deeds. It was actually, I don't remember exactly the language, but it was a temporary conveyance of a time specific.
Was it to the county, though? Is this for property they're using now?
So the property hasn't been fully utilized as of yet. This would convey that to them. The Commonwealth is willing to do it. It's going to go to the county to be used for an inpatient drug treatment center.
And this is a Section 1 bill.
Yes, sir.
Which means it doesn't have to be in the code. All right, any discussion about the bill? All right, been moved and seconded the bill, House Bill 557 be reported. All in favor of the motion, vote aye. All opposed, no. 15-0.
Ayes 15, no zero.
Thank you.
Thank you, Mr. Chairman.
Appreciate it. All right, the next one is Clark, statute of limitations, House Bill 573, Delegate Clark, statute of limitations, medical debt.
Thank you, Mr. Chair. Good afternoon, and to members of the committee. I'd like to move for substitute as an amendment.
Mr. Chairman?
Yes.
Line 29, after the word service, delete the remainder of line 29 through provider on line 31 and insert, or if the patient voluntarily enters into a payment plan within 3 years of payment plan default.
Okay, the import of that is what? Yes, Kristen?
On line 29, after service, delete the remainder of line 29 through provider on line 31 and insert, or if the patient voluntarily enters into a payment plan within 3 years of payment plan default.
The rest of the line 31 through 33, that's still there, right?
Yes, the definition of medical debt would stay.
Okay.
Well, Mr. Chair,
Yes, Senator,
Kristen, then can you tell me
Deeds.
what this bill does then? What we end up with?
Well, it reduces the statute of limitations on a written contract for medical debt from 5 years to 3 years. It would keep an unwritten contract still 3 years, and it would include the Commonwealth in the ability to plead the statute of limitations against, which we don't normally do.
Okay, so this is from the Virginia Poverty Law Center, right? They're asking for the bill?
Yes.
Mr. Chairman.
No, this was a bill that I introduced, but they are supporting.
Okay. All right, tell me what gave rise to the bill?
Yes, I can speak to the bill. HB 573, which lowers the statute of limitations on medical debt in Virginia from 5 to 3 years. The bill additionally stipulates that the statute will apply to the Commonwealth itself. Current law seen in state code under 8.01/231 states that no statute of limitation which does not express term apply in the Commonwealth shall be deemed a bar to any proceeding by or on behalf of the Commonwealth. What HB 573 aims to accomplish is to clarify that this statute of limitation applies to hospitals, debt collection agencies, and indeed, perhaps most significantly, the Commonwealth itself. Today in our Commonwealth, 1 in 4 Virginians are in medical debt. Once medical debt is sold off by facilities like hospitals or debt collection agencies, purchase them, they can pursue and harass consumers for the whole amount, turning their lives upside down. Lowering the statute of limitations on medical debt will not harm hospitals, and it does not affect the presence of medical debt on credit scores. It would, however, limit the number of years that the collection agencies can continue to solicit payments.
Mr. Chair.
Yeah, Senator Senator Peterson.
Then me.
I like this bill. I think it makes sense. My question, or not even a question, but this may be for staff, is if you have folks that have bought medical debt and they're trying to collect it, or hospitals trying to collect it, and right now it's already past 36 months, but not yet to 5 years, how do we protect those, without changing the rules on them in midstream? So I don't know if you got that question in the House, but
No, I didn't get that question.
okay, well, they're not as clever as we are. Or maybe all they do is debtor side, we do creditor side over here. So we may need to have some type of enactment clause, just basically phasing this in to protect those creditors that are holding debt that obviously, you can't just take away their rights automatically. Otherwise, I like this bill, so I plan to vote for it.
Mr. Chairman.
Yeah, Senator Sherrill.
Mr. Chairman, I agree with the intent of the bill. I'm just not convinced that the way it's written gets to the solution without creating more problems. And the way the bill ought to be written is it ought to say that any debt arising out of medical services provided by a licensed healthcare provider, the statute of limitations is 3 years. And then there needs to be a separate clarification of what accrual is, because these debts right now, it's not clear when the statute begins to run because of the involvement of insurance and when the payment demand is actually issued. And so I think the most simple solution would be something that is clear that there's a 3-year statute for all medical debt, arising out of medical services, and then a separate provision about accrual, and with an enactment clause dealing with Senator Peterson's concern.
Sounds like you just volunteered to do that, sir.
Yeah, I'm happy to, but
There you go.
But that's how it needs to be done, because the problem is the way this amendment we have in front of us right now makes it unclear as to whether or not you're dealing with a 3-year statute or a 5-year statute as soon as this is signed, and so I just think we need to be a little more deliberate about what we're doing. So I think we probably ought to take this by till Monday and try
Why
and
don't
work
we
up a sub in the meantime.
Without objection, we'll take it by to Monday and get it fixed. How's that?
Yes,
Okay,
I find that as a friendly.
Yeah, thank you very much. I think the points were well made.
Thank you.
Well taken. Okay, the next one is House Bill 761, Creasick, Judicial Inquiry and Review Commission.
Mr. Chair, we have a staff substitute for this bill, but if you would allow Mr. Creasick to explain what his bill's about in the first place.
Thank you, Mr. Chairman. So what this does is it requires that state courts within the Commonwealth post signs in a location accessible to the public that notes the availability of and provides instructions to obtain a downloadable electronic version of forms utilized by the Judicial Inquiry and Review Commission, the JIRC, for the filing of a complaint from the official website of the judicial system of the Commonwealth. The JIRC, if you go to the JIRC website, they've got a really easy website to do this. It's a nice website, but nobody knows about it. So that's why we have it here. So I see we have an amendment. Yeah, right in front of the judge. No. It would be somewhere in the hallway, I'm sure. Discreet.
Mr. Chair, what the substitute does is I looked at this bill and I liked it so much. The substitute says that there'll also be posted a form that will give you instructions on how to complain against about a lawyer. So,
Come on. Yeah, hey, what's the Jerk Commission think about this?
Yeah, they've been involved in the whole process, and they're fine with it. Their one concern is that they may get millions of complaints, but we can,
So if you lose the case, you get to complain, is that what it is? Okay, any questions of the patron? We got a substitute, is there a motion to adopt the substitute? Moved and seconded to adopt the substitute, all in favor say aye. Aye, all opposed no, motion carries. Any questions of the patron? Anybody want to speak for or against the bill?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised online.
Okay, anybody, yes, somebody wants to
I do
speak?
have somebody, a witness here,
Yeah, okay,
a
good.
constituent.
Okay.
Good afternoon, Mr. Chair, members of the subcommittee. I support Delegate Creasy's bill. I'm Lisa Sales from Mount Vernon. There's no reason why residents across our state should not be made more aware of the constitutionally mandated JERC, or Judicial Inquiry Review and Commission. Many lawyers don't know this body even exists. It's a body designed, as you probably know already, to receive complaints, monitor, and investigate judges in the Commonwealth, and make certain there's no misconduct perpetrated by judges in the courtroom. It's the only oversight we have to ensure accountability should something go terribly wrong. Most judges are terrific, upstanding, fair, dedicated, well thought, but some also go awry for various reasons. Other states, I looked into this, make certain that judicial complaint forms are more accessible and readily available. Right there on the wall with the other forms and all the clerk's offices across our state, residents are aware that such an important body exists to hold judges accountable to the judicial canons, which govern the conduct and actions of all justices and judges, and Virginia should too. This effort can help shape our judicial system for the better. I don't really care who elects a judge. I just care about preserving the integrity of our courts and having our residents believe in and trust in the process.
Okay.
This effort can go a long way in building up the trust of the people and ensuring their confidence in the system. And lastly, I anticipate that you'll say that the JERC, as the delegate said, would be flooded with frivolous complaints, but those can be triaged out very easily. And it's darn worth the ability to tease out the bona fide ones and nip bad actors in the bud. This will also give us the ability to track bad behavior over time. One complaint against a sitting judge may be nothing. However, a handful over time certainly will demonstrate a pattern of behavior and be useful information to our legislature should a problem arise before the long term or terms of a judge end. Thank you.
Thank you very much. Anybody else want to speak on the bill? Very short.
I'm Jeffrey Jacobs from Reston, Virginia. I stand in support of this bill. Who watches the Watchmen? This is how you watch the Watchmen. Thank you.
All right. Anybody want to speak against the bill? Oh, we got the substitute's been adopted. All in favor of reporting the substitute, vote aye. All opposed, no. McDougal? Anybody have McDougal's?
Ayes 13, no zero.
13-0. Peterson, you vote, well, 13-0. The bill
Thank you, Mr.
passed.
Chairman.
Report is reported.
Thank you. I've got another bill, HB 1327, if it's the pleasure of the committee to hear that one.
1327. Let's see. 1327, civil case, a reimbursement of costs. Yeah, Delegate?
Thank you, Mr. Chairman. What this does is it provides that the court shall not require reimbursement of court costs from the victim of a crime from which a civil matter arose. It would amend Supreme Court Rule 5:35D and fix the legislative gaps so that crime victims, in particular, do not have to pay a perpetrator's cost for document reproduction. And my constituent actually ended up having to pay she was given a bill for over $7,000 from the perpetrator of the crime against her. And so, she has a good story, and I would like her to tell that story. But it's not just her. This has become a growing problem. We've got domestic violence survivors in particular have been hit with large attorney and document reproduction costs. And I think you all know that a page at the document reproduction is like $3.25 a page. It's not a quarter like going to the, like it used to be, or a dime, I think, when Senator Saslaw was doing reproduction. But now it's gone way up.
Mr. Chair. At the beginning of time, okay.
Mr.
They didn't have an ability to do that when I was.
That's true.
Senator,
They had
Andy,
scriveners,
remember that?
yeah.
all right, Senator Peake, you have a question.
Yes, Delegate, was she ordered to pay that, or did he just submit a bill?
That's a good question.
There's
Can we
no
bring her up?
judge.
She can tell you. She actually had to act as her pro se, her own attorney to go in and to fight this bill. So she's got a great story to tell if you have a minute.
Yeah,
Thank you,
come on up,
Senator.
yeah.
Thank you, Mr.
And state your name, please.
Mr. Chairman, members of the subcommittee, or full committee, Lisa Sales again from Mount Vernon. Here's the bluff or the bottom line up front, as service members say when briefing senior military commanders. No victim of violent crime should ever have to pay.
Mr. Chairman?
I'm sorry?
And I'm sorry.
Yeah, Senator Obenshain, go ahead.
And I don't mean to interrupt you before you get rolling, but can you tell us procedurally how it was that you were required to pay? I mean,
Well, I wanted to connect, may I tell my story, sir?
No, just tell them, because they will.
Yeah, go ahead, just explain it quickly if you can.
Go through, just
because I think most of us are sympathetic and want to vote for you,
So-
but I just want to know
What happened?
how it happened.
Just what happened?
Yeah, so
We're all about victims.
after remand was won in my case of sexual assault, there were numerous judicial errors, not victim errors, judicial errors. So the defendant brings appeal to the Supreme Court of Virginia. He wins remand, right? A second bite of the apple, a do-over. 2 days later, I get a bill in the mail for almost $8,000
Mr. Chairman, for your civil case?
for my civil case.
Okay, that's standard. If you lose in the Supreme Court, you end up having to pay. That's standard.
Right, but why should any victim of violent crime have to pay a perpetrator's document reproduction costs?
Yeah, Senator Morrissey.
Okay, maybe staff can, or the patron can explain this, but I'm looking at the statute right now, and it seems to be in two different areas allow the trial court discretion. On line 14, the expense of recording the trial of a civil case shall be paid by the litigants in the manner and in the proportion as the court may, in its discretion, direct. It further says down below that the court on appeal may provide that such costs may, et cetera. So why doesn't that provision that allowing the judge to use his or her discretion give you comfort?
Yeah, Senator Delegate Kriesik.
So that works everywhere except, so what we're trying to do is just take that discretion away for when there's a victim involved in it.
Certainly. Follow-up question. So you talk about on line 18, convicted of a crime. Let's say that crime is a class 1 misdemeanor, reckless driving. The person is convicted in traffic court of reckless driving, a crime, and then that matter leads to civil litigation. And as we all know, that there's a different standard, it could go different ways. Your bill would prevent the court from awarding, in its own discretion, a division of the expense for that transcript because the victim, the defendant had been convicted of a crime in another court, right?
I might need to phone a friend here.
Mr. Chairman.
We've been working.
Senator Morrissey, that's how I would read the bill, yes.
I mean, that.
And you agree that that's not a situation that we would want
No, I
to allow
understand that.
happen?
Right, that's correct. This was, we went through many iterations of this to try to make sure that situation wasn't affected.
Further question, Mr. Chair.
Yeah, Senator
At the
Morrissey.
very least, don't you want to have, I would find the bill more palatable instead of a crime, a felony, but even then, that's my, That's my first question.
I'm sorry,
Can we-
Mr.
can-
Chairman.
It's a
Go
question.
Many
Ms.
felonies.
Sales.
Go
Go
ahead.
ahead, Ms.
Can we-
Sales, go ahead,
Please, Mr. Chair.
go ahead.
Many felonies are reduced to misdemeanors. And then we have assault and battery. And then someone like myself, who is not an attorney, is forced to respond within 10 days to an $8,000 bill, pro se, under duress,
Mr. Chair.
in a state of trauma.
Ms. Sales, you didn't have a lawyer in this civil case?
How do I get a lawyer within 10 days, one? Two, I'd have to mortgage my house to find an appellate attorney that would take the case.
But the case that was appealed from, you didn't have a lawyer on that case,
I did not have a lawyer in the appeal, in the case in chief, no,
or in the appeal?
in the appeal process, right.
Okay. Any other questions? I mean, it seems to me this is standard. In a civil case, if you appeal and you lose, the odds are you're going to have to pay cost anyway.
But I didn't appeal. The defendant who was convicted of the crime by the Commonwealth appealed the case.
But he didn't appeal the conviction.
No, he appealed, he appealed the injuries I sustained in the civil matter.
Right.
He won a remand, which he then lost in the circuit court again. But in the meantime, I had to defend myself pro se in, redundant, I know, I apologize. I had to go pro se and write a brief within 10 days. Otherwise, I would have gotten a judgment of $8,000 as a victim of violent crime.
I guess I'm confused. You filed a civil suit against him.
Correct.
And you lost, and you appealed.
No, no, sir.
You won. And then,
I won the civil matter in the circuit court, and he appealed due to judicial error.
right.
There were multiple judicial errors.
And you lost on appeal. He won on appeal.
He won a remand, yes. And then I won again at the circuit court. But in the meantime, I would have been liable for $8,000.
Well, did you pay $8,000?
No, because I wrote a winning pro se brief. But why should any victim be put in a position under duress to represent themselves when they're a victim of violent crime?
Well, that's standard. If you appeal and you lose, you typically have to pay
I
the
did not
cost.
appeal.
Well,
See, that's,
well, anyway,
that's the rub here. She was not the appellant. She, and
Well, it
I mean,
makes
you're-
you-
That's sort of why I
we're
wanted to
mixing
read my
criminal
testimony.
and
Crime
civil, they're
victims.
totally different things. You can win in a criminal case, the defendant can lose in a criminal case, and then you can file a civil suit and lose that. That happens. Different standards.
I'm not tracking.
Mr. Chair.
All right, everybody understand? Yeah, Senator McClellan?
Yeah, I mean, just editorial comment. I think had we let, the witness had a statement she wanted to read that would have answered a lot of these questions before they got asked. Instead, we just jumped in and started
Is there
peppering her
something-
with questions.
Is there something you want to say that you
Yeah.
haven't said yet?
I would, it's still hard to talk about trauma.
I'm sorry?
It's still hard, sir, Senator, Mr. Chair, to talk about trauma. And so I have scripted myself, and I would like to be able to share my story because I can't do anything about what happened to me.
Go ahead, share your
But I don't
story.
want another victim to go through what I've gone
Share your
through.
story. How long will it take? Go ahead.
2 minutes.
Okay, fine. Yeah.
I want you to imagine for a minute how a perpetrator of sexual violent crime, any crime really, can keep a victim in the court system for 7 years, fighting for protective orders, fighting in the criminal case, agreeing to be a witness in the Commonwealth's case, then fighting in the civil case for her injuries. The victim and the Commonwealth are successful in their cases against him. They win. We won. And so he appeals to the Supreme Court of Virginia, adding insult to victims' injuries and distress, further battering the victim mentally. Okay, so let's assume for illustrative purposes there are multiple judicial errors, errors made by judges, not victims. The defendant wins remand, only remand, a do-over, a second bite at the apple. And the victim must bare her soul all over again and go through yet another trial. How distraught she has been and will continue to be. So the defendant gets a do-over. That's probably the right decision when multiple judges make errors. But how about the error made when 2 days later, following the Virginia Supreme Court decision to remand the case, the victim of sexual violent crime, through no fault of her own, receives a bill in the mail for defendant's counsel for $8,000 for his attorney's document reproduction costs, in which, think about this for a minute, in which defense counsel also takes the liberty to hide legal costs, which the rule doesn't even permit. It doesn't allow for that, but he does it. I worry that our institutions, our systems are set up to re-victimize victims despite the victims' Bill of Rights in Virginia. This is incongruous to Code 19.2-1101, which states victims are entitled to be treated with dignity, safety, and respect. This is hardly respectful or sensitive to charge and send the victim a bill. So when this happens, unless the victim responds within 10 days, 10 days, you're in a state of trauma, you're a victim. And unless I respond, a victim responds within 10 days with a motion opposing defendant's bill of notarized costs, she will receive an automatic judgment for non-payment for juror's error. Again, this is not the victim's error. It's that of several judges in the case. This assumes such a victim of trauma even understands all this legal mumbo-jumbo and can afford counsel to represent her in a case before the Supreme Court of Virginia. That's a lot of added burden on a victim. I'm not an attorney. I didn't have money, and I didn't have time in 10 days to locate one. I was freaking out. I needed to teach myself to write a winning pro se brief, and not surprisingly, I'd never represented pro se in any court. And to do so for the first time before the Supreme Court was daunting, overwhelming, and I'm not afraid to admit had me pressured to the point of tears, pulling all-nighters, my floors lined in documents, reading and researching, trying to figure out how to respond, knowing all the while I'd have to retry the case in chief. But I did it, and I won. But most victims would not be similarly situated, nor should they ever have to be. I got lucky. And now more than ever, this law is important. Why? Because we're expanding our Court of Appeals. So this is going to happen more and more to victims of sexual assault and victims of domestic violence. So respectfully,
Mr. Chair, may I
no
ask the
victim
staff
should
a
have
question?
to pay court costs, document reproduction costs.
Thank you.
Thank you.
Question for staff. I have tremendous empathy for everything that this is the question for staff, for everything that the victim just said, but in all due respect, isn't this a case where we are rewriting existing legislation because of a bad decision from a bad judge on a bad day?
Mr. Chair, I would agree with Senator Morrissey. This seems like an unfortunate series of errors that were made that led to a very bad decision.
Well, Mr.
Chair.
Chair,
Yes, Senator Peake.
I will say, this was, if we are correct, this was not a single judge. This was the Supreme Court of Virginia. This was, how many do we have? Seven judges. So the point of, she is correct, but this bill is not the way to do it. The Supreme Court should be ordered, if there is a remand and not a full reversal and judgment for the other side who appealed, they should never be ordering transcript cost and production cost against a party, and then they remand it for a new trial where the party may win again.
Yeah.
She is completely correct. I don't think this bill is correct. I think we need to pass something that says unless there's a full reversal and judgment entered in favor of the appealing party, the Supreme Court should not assess cost and reproduction cost. If they sent it back, did you win?
I did.
And she won. And she won on retrial. It was remanded. That's what needs to be
Mr.
addressed.
Chair, what about this as a solution? I mean, we ought to talk about this more than just, why don't, on line 18, we strike the word crime and we replace it with felony or misdemeanor sexual assault?
Can we take this back? I have to, quite honestly, I'm extremely confused by all of what you've been saying. I'm totally confused. What happened? I don't understand how that could have happened. Is it okay to pass it back for the week into Monday so we can try to figure out exactly what happened? Okay, is that okay? Without objection, your bill will go back for the week.
Lord have
to next
mercy, I don't know
Monday.
why we don't just go on and vote for the bill. God sake.
It's very confusing. All right. It's going back for the day to next Monday, okay?
All right. Thank
So
you,
we
Mr.
try to
Chairman.
figure out what happened. All right, so next case
So
is
we
what?
need to amend the bill and get it out of here so it doesn't
Hey,
happen again.
no, it's too confusing. It's a bad bill, either that or something terrible happened. We need to figure out what exactly happened. Anyway, so now the next bill is Senator Brewer, House Bill 869.
Mr. Chairman, there are numerous line amendments to this bill. I'm going to pass out, and then the delegate or her speaker can explain them.
Just let me know when you're ready, Mr. Chair.
Delegate Brewer, 869. What's this about?
Thank you, Mr. Chair, members of the committee. House Bill 869 was brought to us by the Family Law Coalition in an effort to address a number of issues that have risen in actual adoption cases. This bill is intended to eliminate uncertainties which have resulted in costly and protracted litigation in regards to the putative father birth registry in Virginia. Have you guys seen the line amendments yet?
I've hard to hear you. What are you saying? Yeah, speak into the microphone. Go ahead. Speak into the microphone.
This is a change that's been requested from numerous agencies, including the Family Law Coalition, in regards to the putative birth father registry.
It's 869.
This actually arose out of Supreme Court of Virginia case where there was some ambiguity.
It's a what? It's a what?
This arose out of a Supreme Court case in Virginia.
Okay.
And Justice Mims requested this be addressed because there was ambiguity.
869. All right, this had to do with adoptions, right? And what are you trying to do with the adoptions?
This is actually cleanup of vague language.
It's a what?
It's a cleanup from vague language in regards to the putative birth father registry.
Okay, there's a substitute, there's some amendments. Is there a motion to adopt the amendments? Is there a motion to adopt the amendments? All in favor of the amendments? Is there a motion to adopt the amendments? Anybody listening? Is there a motion to adopt the amendments? Senator McClellan. All right, Senator Sherwood seconds it. All in favor of the motion to adopt the amendments? All in say aye. Okay, the amendments are adopted. So this has to do a cleanup about adoptions, right?
Yeah, yes, sir.
Okay, and so what is the purpose of the bill?
The purpose of the bill is there was some kind of an ambiguity in the code. So this was actually there was some vagueness in regards to the Barnes versus Berry decision. And so Justice Mims had requested that this code language in regards to the putative birth father registry be cleaned up.
No, I don't know. No, let's do this first. One bill at a time.
And I have a phone friend in case you have any questions.
You want to,
questions,
Jeff?
Mr.
Jeff,
Chair.
you want to say something?
You got this.
Mr. Chairman, members of the committee, Jeff Palmer on behalf of the Virginia Bar Association. This is legislation from the Virginia Family Law Coalition. A number of our adoption law experts worked on a number of changes in response to court cases in the area of adoption to bring clarity because the statutes were unclear or the courts had trouble interpreting those code sections. We do have Colleen Quinn and Barbara Jones on the Zoom who are available to answer any questions or provide more detail. They are some of the leading adoption law experts in Virginia. Thank you.
Okay, good. Who's online? Colleen Quinn.
Colleen Quinn, would you please unmute and begin your testimony?
Yes, thank you very much. Good afternoon, Senators. My name is Colleen Quinn. I'm at the law firm of the Quinn Law Centers, and I've done adoption law for 32 years. And Barbara Jones and I co-wrote the Adoption CLE book for lawyers, the Forms and Procedures book. We've written, I think, the last 5 versions of that, and also teach adoption law throughout Virginia. I'm also a past president of the Academy of Adoption and Assisted Reproduction Attorneys. There are a number of spots in the adoption code that are very confusing that this bill intends to address. One of them is that in one of the sections of the code, it suggests that a court can require both an interlocutory order and a report of visitation, and also an order of reference with a report of visitation. This is absolutely excessive. There is no need for both reports to be done. That is a burden on social services. And so we simply are clarifying that the court can choose one or the other, but not have to do both. So that is one of the amendments that is to the 63.2 1210 and 63.21208 section. I also should let you know that I've worked extensively with the Attorney General's office, with the Supreme Court of Virginia, and also Department of Social Services to refine these changes, and everybody has been supportive of these changes and understands the purpose of them. So another section is the section that Ms. Brewer referred to, Delegate Brewer referred to, and that is the section regarding the Birth Father Registry, Virginia's Birth Father Registry. I represented a young man named John Barnes who failed to register with the registry in time after he was sent a certified letter, and therefore he was denied the right to oppose an adoption of his child. In that case, he did register before the child's birth, but the initial judge found he did not timely register.
Mr. Chair.
This case went on for 2 years and went up to the Virginia Supreme Court, and just basically,
Mr. Chair, I
court
don't think anybody's
found.
opposed to this bill.
Go ahead. Can you wrap it up, if you will, please?
I'm sorry.
Go ahead. Wrap it up.
Basically,
We're good.
Mr. Chair.
Finish what you're saying,
Second.
please. Please finish, wrap it up, please.
changes to the Birth Father Registry make it very clear what a gentleman has to do to register and fix a problem with ambiguity in the word "or" that Justice Mims in his dissent and decision said this needs to be fixed. So that's one of the other fixes. And then the final fix is basically telling a judge that they can enter an order of adoption even though both parents are already on the birth certificate. This is a recurring problem because we need to have adoption orders that secure legal parentage for our foreign families, for other families. And so the judges need to know that it is okay to grant adoption even though both are on the birth certificate. Thank you very much.
Thank you. Right. Does anybody else want to speak briefly in favor of the bill?
Mr. Chair.
Okay, anybody against the bill?
There's a motion to report that's been seconded, Mr. Chair.
Is there a motion to, you don't need to fix the bill. Let's see, you do have a.
We've already adopted amendments.
Okay, we adopted the amendments. Is there a motion to report the bill?
There is. There was a motion and a second.
Is there a second? All in, any discussion? All in favor of reporting the bill, vote aye. All opposed, no.
Thank you, Mr. Chair, members of the committee.
Mr. Chairman.
Mr. Chair, I think that we've come up with a solution.
All right, go back to the bill.
House Bill 1327.
Mr. Chairman, I would like to propose an amendment. I think Charles will tell me if I've got this wrong, but in defining victim, we should put victim, as defined in section 19.2-11.01. Is that right, Charles? In the Victim Rights Act.
That's correct, Mr. Chair. 19.2-11.01.
Which defines crime victims as victims of violent crimes. It eliminates the reckless driving types of situations. I think it's a much more narrow and focused approach. So I would make that amendment.
Okay. Do you have it? Is it in writing? Where's the?
Charles has it.
You got something, Charles?
Mr. Chair, it's basically just inserting after victim as defined in section 19.2-11.01. Okay. That's the amendment.
And that would be in line what?
Line 19.
Okay. Victim of crimes. After crime, say what?
After victim.
In section 19.2-11.01.
After victim, what are you saying?
Comma, as defined in section 19.2-11.01.
That's correct, Mr. Chair.
Okay. All right. Everybody understand it? All in favor of the motion, say aye.
Aye.
All opposed, no.
Mr. Chairman, second.
Okay. Second. All right. Hopefully this will fix the matter. All in favor of the motion to report House Bill 1327 as amended, vote aye. All opposed, no.
Ayes 14, no zero.
14. to 0. Okay, fine. Thank you. Thank you very much. Okay, the next bill, 891. Okay, 891. Lopez. Okay. Got it fixed, right?
Good afternoon, Mr. Chairman, members of the committee.
Thank you very much. Yes, Delegate Lopez.
Thank you, Mr. Chairman. This bill does, it looks like it's very long, but it does a very small thing. It removes the term illegal alien or alien as it pertains to persons who are not citizens or nationals of the United States and replaces it with synonymous language as appropriate in the Code of Virginia. Federal agencies, including federal immigration agencies, as recently as last year, have decided to discontinue the use of this term due to its use as a slur. Care was made with the attorneys to exempt each of the few instances where the federal government still used the phrase and where it was necessary to ensure that Virginia was able to comply with federal regulations. The committee substitute that we have on the Senate side, Mr. Chairman, addressed a term of art that was requested by the Department of Small Business and Supplier Diversity, and also we ensured that we avoided any possibility of a substantive policy change regarding the provision of benefits or specifically any overlap with any changes with how we do things in the Commonwealth besides just the name itself.
So do we need the substitute?
No, there's no substitute on this side. So.
And
All right.
Mr. Chair,
Yeah, Senator.
as we talked about, Delegate Lopez, when we talked about the bill before, we thought that alien was mentioned in multiple other places in the code.
We've exempted it, Mr. Chairman, Senator Deeds, in every, where there has been the federal use is needed. Okay. We've exempted those parts in this bill. Specifically, the term immigration alien query shows up in 2 sections. The Department of Legislative Services suggested this term should remain unchanged since it refers to an official process used at the federal level, and amending it before it's changed in the federal law might cause an unintended change in Virginia law. The other places in the name are in the names of federal programs, systematic alien verification for entitlement programs, the SAVE program, also the United States Department of Justice State Criminal Alien Assistance Program. And most of the instances, Mr. Chairman, in Title 38.2 are in reference to insurance, alien insurer, so those are not amended in this bill. So we've exempted each of the areas where there might be a problematic policy issue.
Okay, any questions to the patron? Charles, in good shape?
Mr. Chairman, I think it's in good shape.
Okay, all right, is there a motion? Is second? All in favor of the motion to, yes, Senator Sherville.
Yeah, Mr. Chair, I talked with the patron about this earlier, but Charles, I believe the term alien appears in the code of the administrative code as well. I mean, do we need a directive to the administrative code to clean that up too, or do we just leave it as is?
Senator Sherville, I think that's one of the issues that the delegate just addressed. This wasn't intended to strike alien in every section of the code because in some places it's used for as I guess a term of art or.
I know, Mr. Chairman.
Yeah, Senator Sherville.
I agree, and I heard what he said. My point is that I believe the term appears in the Virginia regulations as well, where it's not used as a term of art, it's used as a term that he's trying to address. And if we're going to clean it up in the main code, the regulatory code might be another place, but I think perhaps maybe an enactment clause directing somebody, the code commission, to take a peek at it might be a good idea.
Or a letter to the code commission might be a better way to do it.
Something like that, yeah.
Mr. Chair, or you could write a letter to yourself directing the code commission.
Right, yeah.
If we could just do that, that'd be great. As Senator Sherville and I discussed in his office, I'm more than happy to send a letter about the regulatory process.
That's fine with me.
Send me a letter. We normally in the code commission don't deal with regulations, by the way, but anyway.
Mr. Chair, I believe the code commission has the authority to look at the regulations.
Yeah, we can if we want.
It's often, not often used, but you do have, the code commission does have that authority.
Yeah. All right, there's been motion to report the bill and seconded. All in favor of the motion, vote aye. Aye. All opposed, no. Okay.
Ayes 10, noes 4.
10-4. You win.
Thank you, Mr. Chairman, members of the committee.
Thank you, Delegate. Appreciate it. Next is 1132, Delegate Williams, payment of small amounts to certain persons without involvement of a fiduciary. Okay, Wynn, how you doing?
Good, how are y'all?
Welcome.
This is an easy bill. Basically, I think you will recall last year where we increased from 25,000 to 50,000, some of the personal injury type things. This follows up on that. It would allow the increase of the threshold. Anything under 50,000 instead of 25,000 would now be allowed to be given out, dispersed without a fiduciary.
Okay. Any questions of the patron?
I think this is a very good bill, long overdue.
Okay. Where'd it come from?
I believe it came from the Boys Graves Commission.
Yeah, Boyd Graves, okay. Any discussion? All in favor of the motion been made to report the bill. Senator Deitch seconds it. All in favor of the motion, vote aye. All opposed, no. Motion carries.
Thank you.
Mr. Chair.
Yeah.
Ayes 14, no zero.
Okay, 14-0, the motion carries. Yeah, Senator McClellan.
Before we move on, can we take House Bill 434 by for the day officially?
It's for which one?
434?
430. Yeah, 434. We'll take that.
Monday.
Yeah, by for the day. I thought we were doing that anyway.
We hadn't officially done it yet.
Okay. Without objection, 434 House Bill will go by for the day. Without objection. Okay? Now, where are we?
Mr. Chairman,
Yeah,
House-
Senator, Delegate Head, yeah.
Delegate Head is in our General Laws Committee. Can we take this by temporarily?
Sure.
In hopes that he will be able to get back?
Go by 1234, we'll go by for the temporarily. House Bill 1236, Delegate Jenkins. Welcome.
Thank you, Mr. Chairman. Mr. Chairman, House Bill 1236 was brought to me by the Apartment and Office Building Association. It passed out the House unanimously. It seeks to encourage persons receiving unlawful detainers to appear in court. Tenant advocacy groups discovered that many tenants facing evictions fail to appear in court in response to a summons for unlawful detainer for fear of losing their job. This bill intends to educate tenants by providing some awareness of the protections provided in the code by including such information directly on the summons for unlawful detainer form. And that's simply all this bill does, is include that information on the summons for unlawful detainer. Again, it's just to educate the tenant of their rights when they appear in courts.
Any questions of the patron? House Bill 1236. Have any speakers?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now.
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert, Virginia Apartment Management Association, as well on behalf of the Apartment and Office Building Association. We are grateful to the patron and we support the bill. Small, simple notice bill.
Okay. All right. Anybody else want to speak one way or the other? Any questions? Okay. It's a pretty simple bill. All in favor of is there a motion?
Move the bill be reported.
Move that House Bill 1236 be reported. Is there a second? All in favor of the motion, vote aye. All opposed, no. Motion carries. I expect.
Thank you, Mr. Chairman.
Ayes 14, no zero.
14-0. Okay, thank you, Delegate. Appreciate it. Okay, now Wiley, House Bill 1278, conveyance of certain property.
Mr. Chairman, I think this is a simple property transfer bill with no issues so far as I'm concerned. Unless there's any opposition, then I would move to report.
This is Section 1 bill, I guess, right? No? Okay. There's, provides the Commonwealth conveys parcels of between Rabbit Creek and the Commonwealth. The motion been made and seconded? Is that right, to report the
Yes.
bill? Okay. All in favor of the motion, vote aye. All opposed, no.
Senator Morrison. Ayes 14, no zero.
14-0, the motion passes. The bill is reported. House Bill 1282, Delegate Glass, sharing of forfeited assets.
Thank you, Mr. Chair, members of the committee. House Bill 1282 is a very simple bill designed to give law enforcement agencies more options to promote trust and cooperation with communities they serve through the use of forfeited assets. So I'm going to be brief and be off with this. This legislation clarifies the definition promoting law enforcement. It's in the context of spending proceeds from forfeited assets, saying which may include expenditures to strengthen relationships between community and law enforcement, encourage goodwill between community and law enforcement, to promote cooperation with law enforcement. Now, I certainly overstand the sentiments expressed by some on this committee that I talked to recently about regarding the profit incentive and abuse of power as it pertains to forfeited assets, and I share those concerns with property rights and due process aspects of permanent forfeiture without conviction. There is certainly work to be done, and I look forward to doing it with some of you. But the spirit of this bill, particularly, is acknowledging that this lack of investment in community leads to the erosion of trust and goodwill with the local law enforcement agency, and is directly connected to trying to solve problems with crimes, especially violent and sexual crimes. I believe that this measure, taking this measure, and our legislator can give our law enforcement officers more tools to build trust and goodwill with the communities that they're called to serve.
Okay. Any questions? Senator Morrissey.
Thank you, Delegate Glass, for bringing this bill. Question is on line 23, and we talked briefly about this. I see that the language for community investment or revitalization that may was struck from the original bill. I like that language. I think it should be included in. Can you explain why that was struck?
I'm not necessarily certain as to why it was struck, but it speaks to the sentiment, the overall, the spirit of the bill was really to say that we want to take some of those forfeited assets and be able to reinvest them back into communities.
Further question.
Yes, Senator Morrissey.
So you would like, to see that language reinserted into the bill, to wit, the phrase for community investment or revitalization that may.
I would agree to having it in there, as it doesn't change. It certainly clarifies exactly what we're trying to do with this bill.
Mr. Chair, I would just add that by including that language, you are limiting the bill. I think as written, the reason why they struck it was it allows for expenditures to strengthen relationships between the community and not so much to limit it just for community investment or revitalization, where if you include that language in there, it would be limiting language.
Mr. Chairman.
Yeah, Senator, Stanley.
Charles, but though, couldn't you make it more inclusive where that is including but not limited to community investment and revitalization?
Includes does mean not limiting by the code. I would just say that this is just, I think, clarifying language, because you're not expanding the pool of money available currently to law enforcement agencies. You're just explicitly providing that this is one of the, I'll say, allowable uses for this money.
Mr. Chairman.
Yeah, Senator Deeds. Yeah, Senator Stanley.
Or Deeds, you can call me Crew. But I guess what I'm looking at this is when you take it out, you're looking at strengthening relationships between community and law enforcement. That could be just like a picnic or a pickup basketball game.
Correct.
When you say community investment or revitalization, those are very specific words in the code that I think empower this bill, don't limit it.
I do not disagree with you, Senator Stanley, Mr.
So
Chair.
can you wordsmith it to make it an empowering, not limiting language?
I certainly can.
Then I so move that he does.
Mr. Chair.
Yeah, Senator Deeds.
I want to ask Charles a question. Right now, this money is limited to law enforcement purposes. Is that correct?
That's correct, Mr. Chair.
Mr. Chair, is there anything about this that would prevent a sheriff, let's say running for re-election, from holding a community-wide rally and plastering his name all over the place, where his opponent might not be able to have such an event at public expense?
So, Mr. Chair, the program is run by DCJS, and DCJS does have specific guidelines as to how the money is spent. I think in the manner that Senator Deeds is referring to, would run afoul to those guidelines. I'll say I can't remember the guidelines specifically, but in the manner in which you're talking about it, it's not so much, I think you run afoul of that is attempt to boost your election campaign, not necessarily to promote law enforcement. And the I'll say, from what I remember, DCJS can claw back the money, they could suspend you from the program. Also, keep in mind that these are state dollars and Commonwealth dollars, so it could potentially also lead to a criminal charge if it's deemed to be fits one of the, I'll say, some sort of criminal charge.
But, Mr. Chair,
Senator Dees.
so what you're telling me is there are going to be regulations that govern this, that come from the DCGS? And so a law enforcement agency or an elected law enforcement officer is not going to be able to use this money for any self-promoting purposes?
That's correct, Mr. Chair.
Okay. Any other questions?
Yes, Mr. Chairman.
Yes, Senator Chair.
And I assume that
Lucas.
there's some formula by which you divvy up these funds when you get ready to share, right? Is there some percentage or?
It is, so as was stated, DCGS there's a formula to how these funds, it's called the use of equitable shared property, so if Chesapeake and Norfolk did a drug raid, there is a percentage, all
Okay.
that goes to DCJS and it comes through the program back to the localities
Okay.
in a percentage kind
Okay,
of
but
way.
that percentage is considered, you come to those percentages by the department?
That happens through the program with DCJS.
Okay. Any other questions?
Mr. Chair, so to pick up the potential amendment, what I would suggest is have the new language read, which may include expenditures to strengthen relationships between the community and law enforcement, and then put including community investment or revitalization, or encourage goodwill between the community and law enforcement, or promote cooperation with law enforcement.
That's a amendment instead
I'll
of
make
the
that
existing
motion.
language, right?
That's correct. So by placing community reinvestment or revitalization, I'll say after the strengthening relationships language, it would illustrate the type of strengthening relationships. It wouldn't necessarily limit it. That would be more illustrative language than limiting
The
language.
motion's been made, and is there a second? Second. All in favor of the motion, say aye.
Aye.
All opposed, no. Okay, is there anybody else want to say something? Somebody else want to speak? Go ahead.
Mr. Chair, Senators, I'm Tracy Quackenbush Martin. I'm here on behalf of the Virginia Association of Commonwealth Attorneys. I'm the elected Commonwealth Attorney in Halifax County. We are very much in support of this bill, both before amendment and since.
Okay, any further discussion? Is there a motion?
Move the bill be
Motion that the bill as amended be reported. All in favor of the motion, vote aye. All opposed, no. Vote no.
Ayes 14, no zero.
14-0. Bill
Mr.
is
Chair.
reported. Thank you very much.
Thank you.
What else we have? Are we finished? How about, 1332 Greenhall, is that it? Covering a security camera in correctional facility, penalty. Yeah. I don't think we've done it yet. Yeah, we haven't done it, have we? No, we haven't done it. Okay, Delegate? Welcome.
Thank you, Mr. Chair. House Bill 1332 is the companion bill for SB 700, which passed both the Senate Committee on Rehabilitation and Social Services and the Senate floor unanimously.
Mr. Chairman?
Yeah, Senator,
Sorry,
Searle.
if this bill is identical to a bill we already passed unanimously, if council could confirm that, I would move to report and re-refer to finance.
Council,
Mr. Chair, so there was a substitute that was proposed in rehab, so and then this substitute may, I have to double check if it matches that substitute. But if it does, then yes, that would be the correct motion, just to send it up, because it did report unanimously.
so you think it is? She said it's identical to SB 700, is that right?
I'm just checking to make sure all these substitutes are identical right
Okay.
now.
Can we just take a
If
few
you-
moments?
Yeah, I can find out.
Mr. Chairman?
Yeah, Senator Searle.
Does the patron know whether or not she conformed her bill to the Senate substitute
Yes.
before it left?
Yes, we did pass the substitute.
It
in
is
the
identical,
House.
Mr. Chair.
Yeah, okay.
So, Mr. Chairman, I would move to report and refer to finance.
Okay, it's been moved and second to report and re-refer to finance. All in favor, vote aye. All opposed, no. Let's see.
Thank you, Mr. Chair.
Okay, thank you very much.
Ayes 14-0.
14-0. Okay, Senator Delaney, okay, Delegate Delaney.
Thank you, Mr. Chair.
What was this?
Good to see you, committee.
What's the number?
HB 404 is before you.
404, okay. Senate House Bill 404, Delegate Delaney.
Thank you, Mr. Chair. House Bill 404 gives localities the ability to allow forensic nurses to testify via two-way video conferencing. While SANE nurses are not fully available across the Commonwealth, the pursuit of justice is not fully available for all victims of sexual assault. So especially on rural corners of our Commonwealth, forensic nurses are put in a position of deciding if they can appear in court or not. And their appearance in court could leave their hospital systems critically understaffed while away. And conversely, not showing up could deprive a victim of justice. So giving localities the ability to allow forensic nurses to testify remotely in the circumstances laid out in this bill would certainly ensure an improved access to justice for victims, as well as continuing to leave the hospitals where they work properly staffed as best as they can be.
Does this have to go to finance staff? No, okay. You got some people in favor of it briefly. Is anybody against it? Why don't you just step up and say who you are and then very briefly, because the bill's in good shape.
Good evening, Mr. Chair. My name is Erin Earp, and I'm Senior Legislative Policy Counsel for the Rape, Abuse, and Incest National Network, and we're in support of the bill.
Okay, thank you. Next, very briefly.
Catherine Ford with the Victim Assistance Network, and we support the bill.
Okay, thank you. Next.
Tracy Quackenbush Martin, elected Commonwealth Attorney in Halifax County on behalf of VACA. We support
There's
this bill.
no
Thank you, sir.
opposition to the bill. Is there a motion?
Where are the-
Mr. Chair, Mr. Chair,
whoa.
just slow it up for a second. Question.
Where are the progressive prosecutors?
Well, they're not here. Is anybody here want to speak one way or the other? Okay. Motion is made to report and
Mr.
to
Chair?
report the bill.
Report. In a second.
All in favor of the motion, vote aye. All opposed, no. Or,
Don't worry about it. Jesus Christ.
No.
Ayes 12-0.
12-0, the bill is reported.
Mr. Chairman?
Yeah, thank you very much. Yes,
Mr.
sir.
Chair, I believe Delegate Bell is on his way from courts to present on 1352.
And I don't know whether it's the chair's desire, but Mr. Benedetti could certainly address Delegate Head's bill, which cleared the House, I think,
Okay, yeah.
unanimously or virtually, if.
Benedetti, would you like to address Delegate Head's bill? Which number is that?
Well, thank you, Mr. Chairman. Matt Benedetti, representing the Virginia Creditors Bar Association.
Mr. Chairman, it's
This
House
is my
Bill
penance.
1234.
This
is my penance
House Bill
for.
1234.
Yes, House Bill 1234. This is my penance for asking Delegate Head, who doesn't appear in courts or judiciary, to carry a bill for me. So what the bill does, it deals with a bill that we had last year around judgments. And there was a delayed enactment clause on that for 6 months. So the first part of the bill in section A clears that language up to make sure it captures anything that happens in that 6-month period as far as judgment goes. The second part of the bill in B adds some language to the creditor's assignee, so it's just cleanup language. And the last piece in section C, lines 55 through 58, basically is intended to allow all liens to be treated equally, whether they come from circuit court or general district court. And then everything after that in section G is just taking some of the language in B and putting it on the form, the short form. And that's all the bill does, Mr. Chairman.
Mr. Chair.
Is there any, Senator Obenchain?
Matt, is anybody opposed to this bill that you're aware of?
That I'm aware of?
Yes, sir.
No, sir.
Is there anybody who would like to speak for the bill or against the bill? Okay.
Be reported.
Second.
Been moved and seconded, the bill be reported. All in favor of the motion, vote aye. All opposed, no. Motion
Thank you, Mr. Chairman, members of the committee.
Ayes 14, no zero.
14-0, the bill is reported. Any other bills?
Mr. Chair, as I said, Delegate Bell is on the way. I would just note that Delegate Bell asked staff to take a look at this bill to see if there's any unconsequential. It's House Bill 1352. And in reviewing this bill is almost identical to another code provision we have dealing with child day centers and family day provisions. Basically, that would prohibit any of those centers from retaliating against any person who in good faith reports child abuse. It's, I'll say, still identical to that same code section.
Mr. Chairman.
Yeah, Senator Serval.
We passed a separate statute to create a cause of action for employee retaliation, and I'm wondering, A, why it wouldn't be there, or B, I don't understand what the enforcement mechanism for a statute where he's placing it under 22.1, 291.3:1 is that, if you got retaliated against, what would you do?
Charles?
So, Mr. Chair, I don't believe this creates a cause of action other than.
It doesn't, yeah.
It is a statutory provision that sometimes statutory provisions would be interpreted by a court to, impart some sort of duty, but that would be the extent of it.
Yeah, you could probably have a cause of action based on a statutory provision.
Mr. Chairman?
Yeah, Senator Serval.
This would create a Bowman claim, would it not?
What? Bowman.
A Bowman claim, a common law action for wrongful termination that was recognized by the Supreme Court in the early 1980s under Bowman.
Yeah, it could be. Okay.
I believe so, Mr. Chair.
You want to wait for Delegate Bell? Should we go ahead and
just retaliate?
And I would note the identical provision, or almost identical provision, is 22.1, 289.045.
Delegate Bell, we're dealing with your
tell
bill.
You, it's
House
almost
bill.
exactly like 22.1-289.045. Good evening, Mr. Chairman, members of the committee. I was before one of your other committees. I had an itty-bitty bill that came up, and we wanted to make sure that staff had a chance to really kick the tires because it didn't come through courts. It came through education on our side, make sure there weren't unintended consequences. We have similar protections for people to make these in other contexts, as staff has said. And it's about as small a bill as it could be. I just want to make sure we didn't mess something else up.
Okay.
Thank you, Mr. Chair.
Any other discussion from anybody? Anybody want to speak in favor?
Mr. Chairman, I have a question for the patron.
Yeah, Senator Serval.
So, my concern isn't with the intent, it's with the execution of this. So what I raised with staff as you were walking in was, I'm not clear how this would go about being enforced. And I think it would probably create a basis for a Bowman claim.
And that was what I thought it might.
Okay,
Yes, sir.
but we also passed a code section in 2020, Delegate Delaney's bill, which created a statutory cause of action for employee retaliation, which also has better remedies than Bowman does. And most people dealing with retaliation are suing under that statute instead of Bowman. So it would seem to me that the better place for this would be in the employee retaliation statute, or some language in here saying that this squares with the employee retaliation statute and not just a Bowman claim.
Mr. Chair, this is why I wanted it to be brought, frankly, before this committee. This is not an area in which I practice, brought to me as a concern, wanted to make sure that it didn't have unintended consequences or couldn't be done better. I'm not wedded to the language. If there's a better place, or if the committee concludes that the risks outweigh the rewards, then don't do it. I just wanted to.
I don't have any problem with the bill. Yeah, anybody else have
Well,
anything?
Mr. Chair,
Yeah, Senator McClellan.
So this is the public school section of the code. In the House, I see it went through education. Did the school board association, or they're the ones that would have to deal with what happens if it's violated? Did they take a position? Did they raise?
They did
concern?
not. Now, again, this is ironically when a bill gets 30 seconds of consideration in a non-courts or judiciary committee, it doesn't make me feel better. It makes me anxious. And so it was a joke, but in the history of time, no one has ever asked for a bill to be sent, begged for a bill to be sent to judice. I did. Here we are. And I just, again, when I don't practice in an area, it makes me nervous to be making changes. They had no objection, went through unanimously, flew out.
Mr. Chair.
Yeah,
Well, let me just.
Senator McClellan.
Yeah, was Stacy Haney or anyone from the school board association in the meeting when it was heard?
Yes, ma'am, but they were not, I don't know how closely they were paying attention either. I don't want to throw anybody under the bus, but if,
Mr. Chairman?
Yeah, Senator Sherrill.
What I would recommend is that we just make an amendment to add to section 40.127.3, a subsection 6, which, says anybody who violates this new code section.
Mr. Chair, I'm going to suggest we take this by for the day for two
Fine.
reasons. One, no one on this committee, including staff, practices law in this section of the code. I don't know whether Title 40 includes or excludes school personnel, because there's usually a whole section of the code that deals with hiring and firing of school personnel. And we could create more unintended consequences because none of us practice in this area. I would feel much more comfortable if this went by for the day and we talked to either Ryan Bremer and or Stacey Haney. Yes.
And I'd like to know what John Davidson thinks of this.
that's a good idea. That's a good idea, actually.
John who? Did you say?
I practiced with somebody who does this kind of law, at least a little. Thank you.
All right, without objection, we'll go by for the day.
Thank you.
All right, any other bills? Okay, if not, we've completed the docket.
Charles.
And the meeting will adjourn.